Well, good morning. My name is Darren Richardson, and I am an attorney with the Law Office of Eastman Estate Planning. We're an estate planning law firm here in Arizona that practices exclusively estate planning. And I just wanted to take a couple minutes this morning to discuss a question that comes up quite regularly when we meet with clients or prospective clients of the firm. And that is, how do I leave my residence to a loved one after I've passed away? Well, in estate planning, there are a number of different estate planning tools that can be used to transfer assets after we passed away. Particularly with real estate, there's three general options that we utilize on a regular basis. The first one is the use of a beneficiary deed. A beneficiary deed is a special kind of deed that is used in Arizona that allows you to name a beneficiary to receive your residence after you pass away. So that deed needs to be prepared and then recorded in the proper recorder's office of the county where the home is located. And then once you have passed away, a death certificate gets recorded, and then that property can be transferred to the beneficiary that's named on that deed. The second way you can leave a residence to a loved one after you've passed on is through a last will and testament. A last will and testament is an estate planning tool that allows you to name a personal representative of your estate and beneficiaries that you want to receive your estate after you've passed away. And within that last will and testament, you can include specific directions for the residents to go to a particular beneficiary, and then that beneficiary is entitled to receive that piece of real property. One thing of note with regard to a last will and testament is that in order for that transfer to occur, it does require probate in most cases for that piece of real property to transfer to your loved one. So if you want to keep your affairs out of the probate court, that's just something to think about before utilizing a last will and testament for that transfer. The third option that we typically see, and is our most preferred option to leave your residence to a loved one after you've passed on, is through the use of a revocable living trust. A revocable living trust, similar to a last will and testament, allows you to name someone to make sure that your wishes are carried out after you've passed away, and also allows you to name beneficiaries of your estate. You can leave provisions within your trust that directs that your residence goes to a particular beneficiary, and then it's up for your successor trustee to make sure that that property gets transferred accordingly. Now, different from a last will and testament, a revocable living trust does not require probate in order for that transfer to occur. It can be done privately outside of the court process, which is typically much more preferred, much more cost effective, and an efficient manner to transfer the residence after you've passed away. So those three things are, generally speaking, the three primary options to leave a residence to a loved one after you've passed away. Before you make any decision on what the best mode of transfer is for you, it's always recommended, and we always recommend, that you meet with a qualified estate planning attorney to discuss the pros and the cons of each option, and then ultimately you can make an informed decision about what works best for you. So if you have any questions with regard to this, feel free to contact our office, and we'd love to meet with you. Thank you.